Okay, so perhaps we'll kick off and we'll hand over. So welcome everybody to the third masterclass in the series leading up to the New South Wales Privacy Summit. Let me begin by acknowledging the traditional custodians of the land on which we meet today, despite the fact that we're meeting digitally. Each and every one of us is sitting on the lands of traditional owners. In my case, it's the Gadigal people of the Eora Nation. Let me pay my respects to elders past, present and emerging. Thank you all very much for coming. As mentioned, this is the third in the series. We have 2 hours tonight with two really world-class experts to talk to us about some of the most important issues of living with privacy in a digital world, in fact, in extraordinary circumstances. We're joined by Professor Kim Wetherill and Peter Leonard, who will take us through some of those important factors. And the intention is to surface those important issues before we get into the Privacy Summit, which takes place this Friday at the end of Privacy Awareness Week. There will be, for those attending the summit, there will be a short 7-minute video summary of the most important points from tonight. But in fact, now is our opportunity to speak to the real live people in this real live digital world. So without further ado, I'd like to welcome Kim to take over the next step.
Thank you, Ian. And again, I'd like to add my thanks to everyone here. It's great to see so many people and so many names I recognise. And thank you, Ian, for the opportunity. And of course, I'd like to add my acknowledgement to the custodians of the lands we now meet on and pay my respects to the elders past, present and emerging. So I'm going to kick right off and what we're going to be talking about today is this question of the, sorry, have I managed to share that yet? Yes, I have. Excellent. Yes. Good, just checking. We're going to be talking about data privacy in an algorithm-enabled world. And of course, as Ian mentioned, this is the third of these masterclasses. And we've already surfaced some really important questions and some really important issues in the course of these classes. We've, in the first class in particular, we were identifying some core values, things like the rule of law, rules against no arbitrary exercises of power. And then we had Verity and Teresa talking about the importance of democracy and participation as a core value that we want to be reflected in any laws that we're developing in this space. And the importance of this concept that's on everyone's lips as we talk about these privacy issues, this question of trust, what's important for building trust. We also, in the course of these masterclasses, have identified some really core problems. We've identified a major deficit of trust, the problem of relying on this sort of trust me concept rather than really organisations really going out of their way to prove that they are trustworthy. Lyria and Malcolm talked at length about the failures of transparency around data collection and use, the failures of predictability and accountability. They talked about the problems that we have in this kind of binary balancing world we find ourselves in, where we balance privacy against security or privacy against health, which doesn't make much sense. We heard about how complex all of our legislation is, the absence of some really important language around questions of ownership and control, custodianship of data. And of course, we've heard something that I think everyone in this room would be familiar with. We've heard of the problem that consent is just not a panacea. In fact, it's not even an adequate frame for thinking about what is going on now. Today, we want to get into a few questions that arise following on from a lot of that. One of the first theme that I'm going to be dealing with is this question of what does privacy mean today? What does it mean in an algorithm-enabled world, in a world where we have machine learning and big data and all of those things? And then we'll shift and Peter will talk about how we bridge questions of principle, some of these bigger picture questions that we might all be able to agree on, and bring them into practice. How do we make our practice better? How do we achieve the fairness or the accountability or the transparency that we might all want in the way that we use and collect data. And then we've got a couple of case studies where we'll talk about these concepts, the big picture concepts of what privacy is aiming to protect, as well as how we bridge principles and practice as a final part of the masterclass. So that's the broad plan. The first thing I want to talk about is this question of what privacy is for. I think we've heard already in these masterclasses, if you've been part of the conversation over time around this space, that the privacy law we have is not the privacy law we need. That there are real challenges that we have in matching what we want to achieve with the technologies that we have today. But I want to take a step back. I think it's really important, if we're thinking of that we want to develop privacy law and practice for this century and for this technological world, we need to be developing an agreement about what privacy is for, what we're actually trying to protect and what the potential harms are, what we're trying to control. And I picked out this quote from Seth Lazar, who's a philosopher at ANU, and what Seth's comment emphasises is that I think what we need to do is we need to reach a genuine sort of collective agreement about what privacy is about and what the harms are and what it is that we're trying to control and what it is that we're trying to prevent. This is right. It means that we need to work on developing the laws and the systems and set some baseline rules, the things that we will and we won't allow, what protective mechanisms we want to build, and when we know we're going to use them. So let's say we wanted to do what Malcolm Crompton suggested in the first masterclass, and we wanted to establish a kind of safety or standards regime where we allocate experts to come up with privacy rules for particular industries or come up with rules that will work for consumers. We would still need to develop a collective sense of what it is that we're trying to protect and what are the harms that we want to avoid. You know, it's one thing to mandate high safety standards for, say, cars or toys, but what are high safety standards for privacy? What is it that we're trying to prevent? I was struck by a comment that Malcolm Crompton made in the first masterclass, which is that the Privacy Act that we have doesn't contain a definition of privacy. Of course, this is actually no accident. Privacy is a really protean concept. By defining certain acts as a breach of privacy, which is what the Privacy Act does, the Privacy Act identifies a non-exclusive set of things that could be done with data in its collection, storage and use that will breach privacy. But it doesn't cover the field of privacy, and it doesn't actually tell us what privacy is, and it doesn't even try to do those. So we've got rules around data, rules around the collection of data without consent, use for unanticipated purposes, rules around disclosure of data. But that's not all of what privacy is, because ultimately when we're talking about privacy, it's not the data we care about. It's what we protect by protecting data. That is human dignity and autonomy. So I want to put to you that data privacy is principally a right that protects human dignity and autonomy. And I've got a couple of lines up there on the slide. You know, human dignity and autonomy, treating us as individuals, demands that we have a right to be let alone, to go about our private affairs in public or in private without being unduly surveilled or monitored. That human dignity and autonomy, respect for me as an individual, demands that I have a right to know when, how, why, and by whom I'm being singled out, especially if I would not reasonably expect or understand what is going on. So data privacy isn't just about data. Privacy isn't just about data, and it's not just a consumer right or a right not to be misled. It's something much more fundamental. Now, where we are at now is that data is being used in new ways that create new affronts or challenges for human dignity or autonomy. This means that without trying to make the Privacy Act some sort of full-service privacy law that protects every aspect of what privacy is about, we do need to extend privacy law and systems to prevent or restrict or control these new affronts to human dignity or autonomy, or the law just won't be doing its job. The really hard work that we need to do is to work out what the harms are that we're concerned to prevent. And in particular, since privacy is not an absolute right, where we're going to rank those harms, how important they are to prevent, how to work out what acts are proportionate and what aren't. So what are these new challenges? Well, I'd like to throw up 4. These aren't necessarily comprehensive, but they're up here for thinking about or discussion. The first is this one I have here, right? The first challenge I think we face in our current algorithm-enabled world is that we're now in a position where decisions about our rights, decisions about my rights or entitlements, can be made via this sort of probabilistic predictive modelling using loads of data about me and lots of other people, including a whole bunch of data that, if it was a human making a decision, you would say that ought to be irrelevant to the making of the decision. So, information about where I grew up, for example, ought to be completely irrelevant to a decision about whether I have certain rights against the state. But what we're seeing is algorithmic systems that sort of predict our behaviour and interact with us on that basis. Now, I would say that the harms that this involves is that it does interfere with my right to be let alone, to go about my affairs without being unduly monitored. If all of this data is going to be collected about me and about what I'm doing and then used to model and predict what I'm going to do next, and if I'm conscious of that, I'm not being left alone. And my behaviour is going to be impacted. My behaviour is going to be chilled. It's also an interference with my right to be treated as an individual on the basis of who I am, rather than on the basis of characteristics I might share with a whole lot of other people I've never met and have nothing to do with. Potentially, as Lyria talked about in the first seminar, it's an interference with our right to equal protection of the law. It shouldn't matter where I grew up or what street I was in. So that's the first of these challenges that I think privacy law is really needs to deal with. And we need to make a decision about how much of this we're prepared to accept. The second challenge is this one of opaque or unexplained processing of data with significant consequences, right? The idea that you could have these outcomes based on some processing of data that you don't understand and that hasn't been explained to you and maybe can't be explained to you depending on how the technology is going to work. Again, I think this interferes with my right to be treated as an individual, so very much an interference with my human dignity. And it risks interfering with my right to equal protection of the law. If I can't understand what is going on, I can't understand how the processing has occurred, how do I know I am being treated fairly? How do I know I'm not being discriminated against? How could I even begin to test that? The third potential harm that I think we're facing, I've put here dragnets or generalised surveillance. Right? Generalised surveillance of the sort of whole populations, including those not really of interest. And here I'm not just referring to sort of surveillance by the government, law enforcement type surveillance. I'm also talking about surveillance capitalism, as they refer to it. The fact that, there's a lot of people watching everything you are doing online, collecting all of that data and just watching you. And that, again, it interferes with that fundamental privacy right, the right to be let alone. It interferes with our right to explore, to experiment without the chilling effect of knowing you're constantly going to be judged. It interferes with other rights like freedom of political association or freedom of industrial organisation. If someone's going to keep the photos of you at the political protest, you might have to make a decision about whether you're even going to go to that political protest or that industrial protest. So these are the harms, and what might follow from this, well, maybe we need limits on facial recognition. I think that's something Peter's going to talk about a bit later on. Another potential harm, and I think this is one of the more tricky ones to talk about, is targeting or individuation personalisation based on sort of a all data approach, sort of lots of data about us being used to personalise services for us. Now, there's a bunch of harms that can potentially arise from that. I mean, again, the right to be let alone, it could chill our right to explore, experiment, other rights like freedom of association, if judgments are going to be made. But particularly here, when I think about personalisation, I think about the potential impact on autonomy. Because if you're able to personalise offerings to people, you are in a position potentially to exercise power over them, to not respect their autonomy, basically to manipulate them to your ends rather than someone else's. So manipulate them into a position where they will buy your service, or perhaps buy your service at a higher price than others. Now, as I said, this is one of the more controversial things to characterise as a harm, because obviously in some cases personalisation is fantastic, right? You know, the most benign version of personalisation is, you know, that sort of single point of entry, tell me once. You know, I don't have to keep telling different departments of government where I live or proving my existence to them. I don't have to keep producing a birth certificate over and over. The use of shared data to pre-populate forms like in tax. You know, this is really benign personalisation, like the good side of personalisation, but not all personalisation is like that. Sometimes it could involve unfair discrimination, charging a person more on the basis that you've detected from your analysis of their characteristics and their past spending behaviour that they're a bit price insensitive, so you just charge them more. Some enforcement, law enforcement, might be quite non-benign personalisation. Targeted political advertising. You know, political advertising that is especially targeted to push your buttons and get you to vote in a particular way. Something that we may well consider a significant harm to the political system. So, you know, there are rules of thumb for thinking about personalisation, whether it's good or bad, thinking about whether the outcome will be fair to the particular affected individual, adverse to their interests, respectful of their dignity. The point I'd like to put to you is that personalisation, individuation, targeting is something we need to think carefully about, and something that it, in some circumstances, could well involve significant harm, including harm to autonomy and manipulation. So I think this is something else that the law really does need to grapple with. So a first question I would have, and I would invite you to raise your ideas in the chat, is, you know, is this a fair characterisation of some of the problems, some of the risks, some of the challenges that we face? And am I right in focusing on the fact that privacy is about protecting human dignity and human autonomy, and that we should think, when we're talking about privacy and data collection and developing our data rules, we should think about how we use the rules to address those harms? Because one of the challenges I think we often see in privacy is that we focus on the rules. We focus on the rules around data, but without paying sufficient attention to the harm we're trying to address. And if we're trying to develop new rules, a privacy law for the 21st century, the first thing we need to get our head around is what are the harms arising from data collection and data use that we need to address, and then we can think about what are the rules we're going to need to address those. Now, a second point that I want to get into a bit is we know that while privacy is an important right and a fundamental right, and one that protects other important rights like autonomy and dignity, privacy is not an absolute right, not in all circumstances. In many circumstances, we're going to have to think about how we protect privacy and also at the same time protect other interests. And you'll notice I'm very carefully avoiding here the language of balance. We're not balancing security and privacy or health and privacy, but what we want to do is address privacy concerns and address at the same time issues of health or issues of security. Now, what that means is that we actually need to reach, I think, some collective views on which of the kinds of uses of data that we're talking about, which of these challenges, and which of the projects or algorithms that we might want to use, that we might want to bring about using data, which of these are the most risky? Which of them involve the most serious kinds of harm? And I want to show you this criticality pyramid. It's not a great name, but it's quite a useful diagram. And what it's trying to get at is that there are occasions where there are some applications of algorithmic systems. There's some applications of data systems that hold such a potential for serious harm that that potential is untenable. It is not something that society should allow for. And in those circumstances, that sort of use of a system or a data system ought to be banned. So that would be the level 1, top of the pyramid, red, all the warning bells going off. And then progressively you go down the list. So you've got, level 2 applications with serious potential for harm, where maybe we don't want to ban, but we want the most rigorous measures for addressing that harm. So things like, constant supervision by authorities facilitated by some sort of live interface that they can watch what's going on. Really active supervision. So that's serious potential for harm. Then you go down to level 3, applications with sort of regular or significant potential for harm. So these are, the harm is sufficiently important that maybe you don't want to use the system without getting ex ante approval first. And level 4, applications with some potential for harm. So maybe you've got some obligations, formal requirements of transparency, published risk assessments, impact assessments, monitoring procedures, audits, ex post audits. The sorts of systems that you could use protection, but you don't feel the need to do those all ahead of time. You might allow the system to operate it, but then keep a close eye on it. And then, level 5, your applications with zero negligible potential for harm, maybe those annoying algorithmic systems that target particular handbag ads at me for months on end. Now, this is a fairly classic risk pyramid, and it's not hard to agree that it makes sense that you would be able to fit sort of particular programs or algorithms or proposals into this kind of assessment. The thing, though, is how do we decide which of these, any given algorithm or program, which they fall into? Particularly, this gets difficult if we're thinking about what falls into level 1. What is the stuff that we simply don't think should be accepted, that it should be banned? and what falls into these other kinds of levels. Because I think it's this conversation that we need to move to. You know, I think we can probably agree on a bunch of principles. We can probably agree, subject to what's the chat, and I haven't been following if there's any chat, but you know, we could probably agree that at least some of the things that I've outlined are potentially harmful. But where they fall is actually a really challenging question. And so I wanted to invite a couple of different kinds of participation here. First, Mark, if it's okay, I'd like you to share the survey that you put together for me. So first, there's a survey, and what that does is it gives you some concrete examples of systems or proposals, ideas that they might have. And what I'd like is your reaction. Which of the levels here this system might fall under, at least, you know, prima facie, on the face of it. I'm aware, of course, that we would want more information about the system, training data, what algorithms, what governance processes. You know, we'd do a proper impact assessment if we were really being rigorous about this. But the purpose here is a bit of a temperature testing. I'm wondering how much agreement we have as this group about those proposals. And if you have comments about the examples, or if there's something that would tip you from level 2 to level 1, if you knew it about one of these proposals, you can absolutely put that in the chat or let me know afterwards. I have a discussion. The second matter that's probably better put in the chat rather than the survey is, so go to the survey and please give us some responses. So I'm curious to see what you'll come up with. But a second matter that I'd be interested to hear from you in the chat is, can you give me examples of systems that would fall into one or other of those levels, but particularly that level 1 or level 2? Can you give me examples of things that you think would fall within the we should prohibit this? This should just never be allowed. Or, you know, level 2, the stuff that we think ought to be approved ex ante. I see Beth's point in the chat there that pyramid classification changes over time as tech changes or acceptance changes over time. And I absolutely agree with you there. The other thing that can impact on what's acceptable, what's not acceptable, of course, or where we would put something, whether we ban it or not, is the circumstances we're in. See, if you'd asked me 6 months ago whether technology that would build a social, like potentially build a social graph that would gather information about who I'd been close to for 15 minutes or more, you know, whether that fell into complete ban or not, I probably would have said 6 months ago, that's banned. That should be banned, right? That's just not okay. Obviously, circumstances have changed. See, and I'm looking at the responses because Mark has helpfully taken over the screen and is sharing this. What I'm finding fascinating here is you'll notice that there's quite a range, right? So, you know, we have people who are characterizing effectively the same system as everything from negligible harm through to untenable harm. You know, say that facial recognition scores. And of course, this is not scientific because of course you'd want to know more and when and how and, as I said, all of those systems. But what I think this is illustrating that's really useful is how extraordinarily difficult these conversations are going to be. And I think that underlines something that emerged from particularly the second of the seminars, which is that we actually need to get a bunch of people involved in these conversations. You know, this group in this room, this Zoom room, this Microsoft Teams room is probably, you know, the legal and technical experts that maybe might be delegated to write some privacy rules. But if we don't agree, I can assure you that there's a broader societal disagreement. I should say is if there's anyone who wants to jump in. Please feel free to open your mic just briefly if you feel the need to join in the conversation here.
So we have about 76%.
Yeah. See, and look, I think that's I'll have a deeper look at these later in a lot of ways, but I think the thing that is jumping out to me most at the moment is the variation. Even on these examples where we've seen quite a lot of variation in the responses. Oh, and we're getting a few targeted advertising for people with vulnerabilities. Yeah, that's a good example, perhaps, of something that would fall into your level 1 or level 2, a prohibition. Thank you, Peter. That's helpful. Okay, at this point in the seminar, I thought I would hand over to Peter. It's Peter's turn. So, Peter, do you want to take over the screen sharing, or do you want me to drive?
Let me just see if I can find the screen and share. And if so...
well, that looks good.
Okay. So...
your screen.
Lovely. So you're seeing 21st century data privacy and beyond?
No, at the moment we're seeing the things thanking you for doing the survey.
Okay, let me just see if I can bring the other screen up. Sorry, the problem always of 2 screens.
Still got the same one, Peter?
Oh, dearie me. All right. Just give me 1 second. Too many things open. Okay, how are we going now?
So we've got your slides in edit mode. Did you want to go into presentation mode?
You're seeing it as PowerPoint, are you? Not the slide itself?
We're seeing the edit mode, not the slideshow.
Oh, dearie me. I thought I had this all queued up. This is why Kimberly and I allowed some extra time.
This is called the demonstration effect, Peter. It's guaranteed to happen.
Perfect. Okay, we're there, are we?
No, we're in your notes slide now, sorry.
Presenter mode, yeah.
Presenter mode, we're looking at your slides.
So is that what you wanted? Are you now seeing 21st century data privacy and beyond?
Yes, but we're
a preview of the next one.
We're seeing your presenter view.
Ah, okay. Well, that's because I've got 3 screens going. Okay, let me just now try and get...
If you go to the top of your screen there, Peter, you'll see display settings, and you should be able to switch it at the very top of that. Yep.
Swap presenter view and slideshow, or
That's
duplicate slideshow? Yep.
Swap it over.
Okay.
There you go.
Beautiful.
Right.
Well done.
Okay. Sorry, what are you seeing now? Are we got the same problem, or are we right?
No, we're right.
Century data.
Okay. Sorry about that. I've got 3 screens all showing me multiple things. Okay. Thanks, Kimberly. And what I'm going to do is to try and bridge the discussion between where we are on data privacy laws and individuation, and where I think we need to go, and what are the steps to get there. And I suppose the first thing I wanted to emphasize is that part of the problem we have today is that the underlying superstructure of 20th century data privacy laws simply isn't fit for the 21st century. And that is because two reasons. The superstructure of data privacy laws as we have them today really is the so-called notice and consent or privacy self-management framework. And what that is about is empowering each individual to make a choice about whether they provide personal information about themselves, and enabling that choice through the person that is seeking that information from the individual, providing them with information that informs them in the making of that choice. And generally the mechanism for informing an individual is the provision of a privacy policy and a privacy notice of collection, coupled with, in some cases, demonstrable consent in relation to collection and uses of more sensitive information. Now, that mechanism has broken down for various reasons, some of which are more familiar to us and some of which are less familiar. The more familiar one is the perception by some users that at least some services are essential to their needs, such as search, social networking, and even some less immediately obvious services, such as job search websites. They're all examples of services where individuals may feel that they need to use the service regardless of the data privacy terms. So the individual's perception of necessity overrides what options they may be offered as to the management of their personal information. Many service providers don't offer individuals a real choice or a real range of choices, or don't offer the choices in a way that enables the individual to start with a more privacy protective setting, and then on the basis of specific information that enables them to determine privacy impact, if they elect to dial down that setting to, in effect, having started at a point which is most protective of their interests, to then decide whether they are willing to dial down those privacy settings in return for more functionality or other benefits to the individual. Data minimisation today is not mandated in Australia, so our Privacy Act doesn't create any obligation on a service provider to limit data protection in any way to what is essential or necessary for the provision of a service. Probably the most important way, though, in which our existing structures have broken down is the break of the link between information about an individual and the ability to affect and direct a service to a category of individuals. And what that in essence means is that today it is possible to target either a specific individual or a segment of individuals using non-personally identifying information. Now, that targeting can either be for good or for bad. So, for example, in the US, there are fair credit rules that in essence require credit providers to make adjustments in their offerings in order to make credit available to less advantaged groups. So it is possible, for example, for credit providers, indeed it may sometimes be necessary for them, to look at areas where there are less advantage, and to actually target credit products to areas of less advantage, but in so doing, being careful in the assessment of individuals within those areas of less advantage. And those rules are quite comprehensive, so they look not only at the immediate identifiers of less advantage, but also factors that may operate as a proxy to indicate less advantage. So sometimes that might be postcode or street, where the street is a fair indicator of socioeconomic status of individuals within a group. So the point is that algorithms now enable the use of proxies which can create individuated effects on individuals, and sometimes that can be positive, such as, for example, in New South Wales, the Their Futures Matter analysis, which is basically aimed at finding areas of disadvantage and then targeting government services to assist those areas or those people of vulnerability. Compare that, for example, to some activities in the online advertising industry where the targeting is enabling ads to be targeted to individuals that may either be viewed by the individual as a positive because they're seeing products that are relevant to their particular interests, or it may be contrary to the interests of an individual where, for example, a advertiser is able to deduce that you've been searching for a product for the last day and then come back to them for that product. So that suggests that you've not been able to find that product at a better price elsewhere. So when you come back, the price might have gone up by 20% from when you saw the price a day ago, even though the default price that is being offered to others remains at 20% below the price now being offered to you. So there's an example of where individuation may be used to your disadvantage, even though the service provider is unaware who you are. They're just aware that you are the same unidentified person who came to their site a day ago, and here you are back again looking for the same product, presumably therefore not being able to find the product at a better price during that period. The other change that we're now starting to see is a greater emphasis not on individuals and their choice, because individuals are swamped with information and it's just too complex to work out how you choose whether to share personal information or not, and moving instead to an emphasis on the accountability of the organisation that is the would-be collector of personal information about you. So that is not only accountability of that organisation in respect of what it wishes to do, but sometimes it might also be an expectation or a legislated requirement that that organisation take responsibility in respect of all of the uses of that information that it might enable in a multi-party data ecosystem. And let's remember now that in the case of almost all online interactions, for example, the organisation with whom you're dealing is in fact an organisation at the centre of or the front of a data ecosystem that often might involve between 5 and 10 other parties sharing information in order to provide you with a product or service. And in that environment, it's very important that firstly, there is clear accountability lines between those various organisations, a clear concept of the risk that arises as a result of the creation of that ecosystem, and clarity as to who is responsible for managing and mitigating that risk within that data ecosystem. The other issue that is coming up more often is the general statutory override that exists under many data privacy statutes of other laws that are inconsistent with the data privacy laws. So, for example, under our Federal Privacy Act and our state equivalents, there is a general override of other statutes to the extent that those other statutes have the effect of mandating the disclosure of personal information. And that override operates generally without any requirement, as it were, for consideration of the relevant strengths of the individual right of privacy and consideration of that against the need under the other statute for that override. So again, to emphasise the point that Kimberly made, this is not about balancing, it's about the consideration of rights, and sometimes that requires a balance, but often it requires a more nuanced consideration of, is it really necessary for another statute to completely override data privacy rights, or is there a more targeted and respectful way of dealing with an individual that would enable both of the statutes to operate together and in tandem? And this becomes very important as we move into a digital trust world. And you see it, for example, in the current COVID safe debate. And it is where you get the juxtaposition of, well, why should I trust data to government when government has had some well-publicised data trust problems, such as the robo-debt and the issues around my health record, so-called census fail and so on. And some people say, well, I can't trust government with my data, and therefore I don't want to take up the COVID Safe app, rather than evaluating the controls and safeguards around the COVID Safe app and considering whether they are appropriate and likely to work in the particular context, independent of the problems that some government agencies have had in the past. So that kind of more nuanced consideration of privacy leads to discussions around issues such as functional separation. Let's not treat an agency as a single monolithic whole. Let's look at who is it within an organisation that needs to have access to what data, how, under what conditions, and what are the appropriate controls and safeguards that they're putting in place. And those controls and safeguards may be technical limitations as to who gets to see the data. They may be operational limitations around the training of individuals who are empowered to see data, and the separation of those individuals either physically or technically or through other procedures from other individuals doing different things within an organisation. And they may be legal safeguards, such as through contracts with other entities that are enabled within an ecosystem to work with data. So the issue always should be, who controls data? Who processes data under the control or direction of the party who controls that data? And is there enough incentive and disincentive built into the system to ensure that they really care, so that the person who controls the data cares what the people that process the data do and institutes the appropriate steps and controls and safeguards to ensure that the handling of that data is appropriate? Now, what we're seeing, though, in response to the inadequacy of our current data privacy laws is an attempt at gap filling through statements of principles. And an example of the kinds of principles that we're seeing is the so-called fast-track principles. And as many of you will know, there's many variants of these core concepts, but the core concepts of the fast-track principles for AI, as explained by the Alan Turing Institute, are fairness, accountability, sustainability, and transparency. Now, when you actually look at the content of those principles, one thing you will find is that those principles overlap with many of the concepts of organisational accountability and consideration of individuation and whether it's beneficial to the individuals concerned and respectful of their dignity and interests. All of those kinds of concepts are actually swimming around in those principles. And of course, the issue then becomes, if you concentrate too much on principles, you can actually be blinded to the inadequacies of existing laws, or indeed the extent to which existing laws might not be inadequate, such that people talk about things as principles that can then be jettisoned if they don't like them, when in fact the law, properly applied as it is, already addresses some of those concerns. So we need to be very careful when we start talking about principles to not start creating a perception of gap that it should be filled by the principle themselves, when in fact sometimes what needs to happen is the law needs to change to become a 21st century data protection law, for example, in order to address some of the issues that are being considered in these many statements of principles that we're seeing. And one example of an extension of the law is a US Congress proposal for an algorithmic accountability act. And this is not in fact an act which has been passed yet. It remains as a bill in the federal houses in the US. But in essence, what it would do is require organisations that are using algorithms to make decisions about individuals, that where the algorithm is built into a computational process, to undertake an impact assessment which looks at various things, and you'll see on those slides the things that are listed as being required within an impact assessment. And there are a variety of these kinds of laws currently proposed around the world, and a more limited implementation of this concept of algorithmic accountability already in the European GDPR. Now, of course, there are many things that can possibly go wrong as we look at AI systems and the use of AI and automated algorithmic decision making. Top of the list always should be, and often is not there, that an organisation just doesn't care, or it doesn't know, or it doesn't explain or see the need to do any of those things. Then there's common faults of how organisations work, wrong accountability and wrong incentives. Think of many of the things that came out of the Banking Royal Commission and the other Royal Commissions of late. None of those involved AI or automated decision making, but they simply show the problems that can emerge if you don't think about accountability and getting the right people accountable, and you don't get the right incentives in place to cause people to be good. Wrong framing of the questions that need to be answered, and that can be a problem, for example, with data privacy impact assessments, which can be perfectly well conducted and never get to the heart of the issue, because all that happens is that an organisation ensures that it doesn't use personal information, but it still achieves an individuated effect, which may be contrary to the interests of an individual, but because it doesn't use personal information, it passes through the privacy impact assessment with a tick. There may be a lack of clear allocation of responsibilities, not considering systemic risk, so that you address risks within your organisation, but not other risks that may be involved in the movement of data into your organisation or out of your organisation. There may be a failure to manage the translation between outputs and outcomes and the residual risk associated with that. So you may have, for example, perfectly good data outputs or algorithms, but used in a way that leaves human error or omission in the way that data or those outputs are being used, so that the outcomes are not fit for the particular purpose that the human decision maker is using those outputs to effect. There can be, and there often is, the issue of washing. So you put an ethicist into the discussion, you put a privacy professional in to do a privacy impact assessment, a lawyer looks at the existing law and gives you a tick, and then you pass it through, even though you've not adequately mitigated the risk of an outcome which is manifestly negative to, non-beneficial to a particular segment of users or individuals to whom data relates. And then, of course, there's the other ones, the other issues that are more commonly identified, but from my experience are actually less commonly the source of the problems as compared to those things that I listed higher up. Poor data inputs, inadequate data, or simply wrong data, poor data science, poor handoffs, and more often the issues are, as I noted before, poor use of good outputs that create bad outcomes, or poor feedback loops, and then when there's a problem, reacting with hubris and just digging in. And just think how long it took for the robo-debt problem, after the robo-debt problem had been identified by many people, to actually be addressed and solved. So how do we bridge the gap between principles and practice? Well, the first thing is that you select an appropriate statement of principles and associated user guides. And there are over 90 statements of principles, many of them drafted for particular industries or types of products. So the problem is not a shortage of statement of principles. The only problem is finding the best one that fits. But then, and importantly, you need to consider how the statement of principles fits with existing laws and regulations that affects your business, whether there are issues as to product safety or standards, international standards or Australian standards, codes that affect the conduct of your business, stated commitments by your organisation as to what it will do or won't do. It's important to consider accessibility as an issue, for example, for people with disabilities, and to ensure that they're taken into account in the design of use of AI and advanced data analytics. And it's important to identify gaps and who is then accountable to bridge the gaps between those things and the existing law. You then would conduct a prelim high-level risk and impact assessment of process outputs and outcomes, and that should include consideration of governance arrangements within an organisation and risk allocation, who's responsible for what and who's accountable for what. You then seek approvals based on that, and you then apply good project management principles and use appropriate tools and methodologies to execute the build and trial of the relevant AI application or automated decision-making process with appropriate quality assurance, feedback loops, etc. You then document the outputs and the residual risks that are not managed, and you assess the allocation of risks and responsibilities, that is the translation of outputs to outcomes, and who should be liable for what, and then you create the feedback loops based on how it all works in practice. Now, in our time today, we don't have time to go through all of the available tools, methodologies, and so on, but I just wanted to highlight in particular the ACS's work around privacy-preserving data sharing frameworks, because I think it's a really good example of how tools and methodologies can be developed that are adapted to the level of risk that is inherent in particular types of activities. And I commend that work, much of which has been led and really driven by Ian Opperman as really useful work. And then there's a range of other accountability methodologies and tools that are available to assist people and organisations through these processes. So at that point, what I'd like to do, Mark, is to offer people the opportunity to contribute some thoughts on how the use of methodologies or tools or other mechanisms for thinking about impact upon individuals can help in consideration of what should be done, what shouldn't be done. So what I'm now trying to do is to invite people to engage in a ranking of what is really important and what is less important as we move into 21st century data privacy and organisational accountability to improve the position from where we are today in privacy, self-management, notice and consent. So what are the things that should be our priorities to address in moving to a world of greater organisational accountability and better ways of doing things to address adverse impacts on individuals? So we've put up on the screen here a ranking of high priority, medium priority and low priority. And Mark and Kimberly, what I was going to suggest is that we might leave this open for people to complete, whilst at the same time we have our comfort stop, cup of tea break, etc. And then we'll come back and Kim will start with one case study and give us an opportunity to participate in that case study, and then I'll do another. So I'm going to suggest now that we open this slide to input from individuals, and while at the same time we give people the opportunity. Let's say it is now 5:06. Shall we come back about 5:10, 5:12 for the third part of this session? Thank you.
Just confirming that everyone's able to get into this document and to edit it. Maybe everyone hasn't had a chance yet. I just haven't seen anything come through.
Mark, at the moment, I've just gone into the document and it seems we don't have edit permission. So that link is not an editing link, it's just a viewing link.
Mark, same with me. I also got into the document, but doesn't seem to
My apologies. Do you want to try the link I've just posted? Sorry. I may have got the wrong link.
Yeah, looking at that second one, I still don't seem to be able to edit it.
Yeah, sorry, it wasn't working. This one, I've just posted another one. Third time's the charm, hopefully.
Third time's the charm.
That's what they tell me. Still no. Ah.
Nope, that one's editable.
That's editable. All right, I've got Tony. Would you like to try the last link that I've just sent? It looks like other people are getting in. Might be that you're on the previous one, or it could be that you've got it cached. So just close down that window.
So Peter, would you mind explaining to me again what you'd like here?
Yeah. Can you hear me?
Yeah.
Yeah. So what I was trying to do was to say, well, okay, today we live in a notice and consent world, and we're trying to move to a world where instead of putting the responsibility on an individual to determine whether they should be sharing personal information in return for or to enable provision of a service, what is it that we would expect if we're going to put responsibility on an organisation instead of notice and consent? So what are the attributes to establish organisational accountability? What are the things that an organisation should be thinking about or instituting itself when it is deciding whether to collect information from me or not? So it may be, for example, that they should be thinking about the harm that they might cause me by, for example, charging me a different price or refusing to offer me a product or service. They should be taking responsibility for all other organisations that they might enable to use information by sharing my information with others. They might have a responsibility to tell me if a law enforcement agency requests access to that data. They might be required to publish a transparency report about how data is being requested by law enforcement agencies and so on. So I'm just thinking, I was seeking to have people think about the range of ways in which organisations that become responsible for controlling personal information might demonstrate to users that they are being accountable and respectful and fair in the way that they handle data. You don't look convinced, Kimberly.
No, I'm just trying to think, because it's you know, all of these things is chat like, you know, what is the highest priority? I mean, my immediate instinct is that, you know, based on some of the other discussion that you had and that I had, that we should be thinking about, you know, broader societal impact assessment, right? But then, you know, so a organisation should try and look at the potential impact on the people affected by whatever data processing or exercises it's doing, and think about the potential impact in terms of equality, in terms of discrimination, et cetera, et cetera.
Yeah. So well, one way to think about it is to say, well, instead of telling me all the good things that you're going to do with my personal data, start by telling me the adverse ways in which that data might be used, or to put it another way, the ways in which data might be used that would be adverse to my interests. And that should be top of the list, and tell me what you're doing to mitigate those risks. Another way would be to say, instead of requiring the individual to make a decision about what's fair and what's not, list the no-go zones. So just make some things impermissible, regardless of whether the consent of the individual is sought. Another way of looking at it is to say, can we list a number of things that would cause significant harm, that each of which would require a very specific form of consent by an individual for that thing to be permitted. So there's a variety of ways in which, as we move away from a notice and consent world, we can try to really narrow down on those things that individuals should be responsible for. And sorry, it's Malcolm Crompton on the phone. I wonder what he's trying to tell me. So that we decide on those few things where consent might really be the gatekeeper, and require organisations to take account for everything else. So I think we should be now back in our third session, Kimberly.
Well, I was just going to push back at you with one question, which is, what would you put as the highest priority?
What would I put as the highest priority?
What would you put as the high priority in this document?
I mean, I think that we need to have a baseline of organisational accountability that applies to all uses of information that can have an adverse effect on individuals, or that individuals would not reasonably expect. And I think that that baseline is that they should have accountability for anyone that they enable in their data ecosystem using or misusing data contrary to the principle that the organisation will only use information in ways beneficial to the affected individual. So I think that really moves beyond the concept of, is it a use of personal information to the individuation of uses of data and what is adverse to an individual. But that, of course, requires quite a detailed and nuanced discussion around what is a benefit, what is a harm, what is undue, what is unreasonable.
Yeah. No, thank you. Okay, so I think we'll leave that open, and I would strongly encourage you to think about continuing to add to that and what the most important things are. But I might move discussion on now, if that's okay with you, Peter, which because one of the best ways to work through some of these issues, I think, is always to look at some case studies, and that sort of bridging from principles to practice in a real world example. And I mean, it may be the obvious example of the day, and I'm sure that people will have multiple views of this, but the obvious example of the day, of course, is the COVID Safe app, and thinking about the processes and how those processes might have been different around COVID Safe in ways that might have improved the outcomes. Not saying that the outcomes have been bad. I think we're very much still in the maelstrom of all of the developments over this app. Every time I open my email, I sort of half close my eyes, given what we might see. But I think, so what I have here is, this is just a picture of the information flows that are going around in the COVID Safe app. This picture, of course, is drawn from the privacy impact assessment that was done for the project by Maddox and published. And I think the COVID Safe app is an interesting question to think through what a sophisticated 21st century privacy law might have asked of something like this, and to test some of the ideas that Peter's just been talking about. So it's also an interesting example because it's an example where you do get the sense, albeit with faults and albeit against a not great background of, a trust deficit, it is an example where the Commonwealth Government at least seems to have tried way more than they have tried in other recent contexts where we've had the gathering of data, tried to respond to privacy concerns and preempt some of the privacy concerns that have been raised, and preempt some of the broader actual concerns around the app being voluntary and making sure that it is genuinely voluntary. So, and I'm thinking there about some of the rules that are in the determination around, not being able to require people to download the app. Now, of course, there are legitimate criticisms of the whole process, and many of those have been raised, including by people who are in this room, and including people like Graham Greenleaf, who's written a nice paper, David Watts, who's written a nice paper already on this. There are legitimate criticisms of the tech and the technology, and legitimate criticisms too of the process and the absence of publishing some of the advice that sits behind the app and some of the views expressed by organisations like the DTA. But I think what two things that Peter talked about when he was talking about what might be included in a 21st century privacy law. One was imposing requirements that a data custodian, someone who has control of data, engages with and perhaps actively polices the whole data ecosystem. So everyone who might be using this app, everyone who might engage with the material in it. And a second thing that Peter has asserted that we need to do is to perhaps do an assessment as an organisation of the broader impacts of an app and the potential broader societal impacts of an app. And I think when you look at the privacy impact assessment on this particular project, the one thing that we are seeing, and I think this perhaps backs up Peter's call to assess the broad data ecosystem, is that the privacy impact assessment on this particular app has fallen short on precisely that. So it's fallen short in the sense that the impact assessment and even the laws that were put in place, the determination that was put in place at the time the app was made available, don't deal with the full data ecosystem and all the potential users and people who can access this data. Now, the most obvious example of this is the absence of rules around, specific rules, specific laws around the state or territory actors who are going to be interacting with this, the contact tracers, the other public health officials in the state system. And the assessment, the privacy impact assessment, more or less sort of leaves that to one side and says, well, we understand there'll be agreements with the states on that. And that is I think that's one of those cases where there's been a failure to upfront address the full project end to end and all of the risks in it. And I think that's particularly interesting / striking, given that this was exactly the criticism that the National Audit Office raised when they looked at what had happened with the My Health record. Again, in that scenario, it was a failure, the failure such as it was in My Health record that was highlighted by the National Audit Office, leaving to one side all of the external criticisms, was that there wasn't, adequate dealing with the risks posed by all the third parties and doctors and commercial providers of apps, etc., that would be interacting with My Health record. And that wasn't properly dealt with. So, and similarly here with COVID Safe, an absence of a proper dealing with the question of the states and the territories is one problem. The other aspect of the broader data ecosystem, which this privacy impact assessment doesn't deal with, and I think this is also important, is the question of US access to the data. So there's been a great deal of discussion amongst experts that I've seen talking about that question of, well, does the Cloud Act apply? Is it possible for US law enforcement to require Amazon to hand over this data? And there's been very, very mixed messages on that. There's been an absence of clear communication and an absence of, legal clarity about exactly what the position is, or whether we're just relying on the fact that we're great friends with the US and they wouldn't dare, given we are such good friends, and it would undermine the whole idea of the app to do so. So I think that's one obvious problem that we've had here that backs up kind of what Peter is saying, which is that, a 21st century law does need to deal with this, kind of end-to-end full data ecosystem. The other thing that I think is interesting when I look at the COVID Safe app is the impact assessment. And it's interesting because I come to this not as someone who's done privacy impact assessments. I've only read a limited number of them. I've studied privacy law, but I'm not a privacy practitioner. And the thing that strikes you when you read this privacy impact assessment is that it talks about risks. Those risks are always talked about in terms of things that might happen to the data. The data someone might inappropriately access the data. Someone might, the data might leak. The data might be hacked. These are the risks that the privacy impact assessment discusses. And of course, there's various ways that these are addressed. But as I think Peter was trying to emphasise in what he was saying, and he can no doubt jump in and correct me if I'm wrong, that's not really the concern for people. And this takes me back to the point I started with, which is that with privacy law, ultimately, it's not the data we care about. It's the people. And it's the impact on people and the outcomes for people that we should be concerned about. And so I think, in an ideal world, if we weren't doing narrow privacy impact assessments where we were working our way through whether there was a risk of breach of the particular privacy rules, I think we would be thinking more carefully about what are the potential impacts on people of this app, of the collection of this data, of the, breaches or release of this data. What's the, as Peter might have said in one of his slides, what is the worst that could happen? What might happen to people? And that raises some of those interesting questions that have been discussed in some of the, in some of the discussion online. Is there a risk that someone who is a domestic violence victim might have the data that is sitting on their phone accessed by someone who's trying to work out who they've been close to for periods of time? Like dealing with those sorts of questions, dealing with the potential differential impact of all of this, whether the large number of people who won't have the right sort of phone, won't have the right sort of technology, won't want to keep the phone on all the time, aren't able to because they work in environments where they can't just sit and have their phone charging while they're working. And I completely appreciate that is not the role of a privacy impact assessment as we have developed them and as they have become this box ticking exercise to a certain extent. But what that isn't doing is is thinking about what's the harm we're trying to prevent. I will say this, the harm of people being sort of effectively required or forced by employers, etc., to download the app was considered, and I think that's really useful, and I haven't seen that sort of thing in these before. But I think we can go further, and that is probably why if I were filling out Peter's form at the moment, which I'm not because I'm talking, one of those first things I would be putting is, an impact assessment that thinks about the impacts of the outcomes for people. Anyway, I'd be interested in your views on this, and of course, because I'm talking and screen sharing, I haven't been able to follow the chat, but I'll be interested to read through your views on some of that in the chat. And I would invite at this point anyone who has any questions or comments that they want to raise, if they want to jump on the mic for a minute or two, if we could probably take a couple of questions or comments before we move on to the next case study. Maybe I'll leave it to the chat for now, or leave it to the discussion at the end. Peter, did you want to jump in with your case study now?
Yeah, and look, I chose a case study that I thought was an interesting fit with this one as well, because it's, I think, an example of what not to do when it comes to impact assessment. And it involves the perhaps not as hot as COVID-19 issue, but the issue of surveillance and facial recognition. So let me just, what slides have we got up now? Kimberly, are you still sharing your slides, or?
No, I think I've jumped out of sharing.
Okay.
Yep, I'm not sharing at the moment.
Okay, well, let me just start talking, and I'll get the sharing sorted out as I talk. So, firstly, the issue of pervasive surveillance of individuals and potentially automated facial recognition. So many of you will know that London is one of the most surveilled cities in the world. The last count is that there was approximately 625,000 CCTV cameras in London. In January of this year, the London Metropolitan Police announced that their trials of use of automated facial recognition had been successful, and that they were about to start with fully operational implementation of automated facial recognition starting on Westminster Bridge. Of the 10 most surveilled cities in the world, supposedly only 2 are outside China. The top 8 are in China, and the 2 outside China are London and Atlanta. When you compare the number of cameras to number of citizens, in London, there's 1 camera for every 14 citizens in London. Now, that is potentially a significant impact upon the right of an individual to go about their daily life without being unduly surveilled. But of course, that right is a right that also exists with the right of individuals to go about their daily lives without being attacked, and the concern of individuals for their personal safety and security. Not that the two need to be balanced, but the two rights need to be taken into account in determining how and where images from CCTV are used, what individuals need to know about how those images are being used, and how you get the right controls around how those images are used. The next issue then becomes that there are other images that are critical, that are needed to be shared to enable all sorts of good things, such as if you've got a Victorian driver's licence and you move to New South Wales and you'd like to prove in New South Wales that you have a Victorian driver's licence and convert it to a New South Wales driver's licence, or you want to get a fishing licence in New South Wales and you don't want to have to go through a complicated identity verification process, repeating what had happened in Victoria already to get one, it makes a lot of sense to have an ability for Victoria to share an image of you and to enable New South Wales to verify that that image was from a current Victorian driver's licence and appears to be the same as the image of you that they may be seeing on Zoom or face-to-face across a counter in a New South Wales customer service centre. So clearly image sharing, image recognition, image verification can have significant benefits for individuals in a country like Australia, where you've got 7 state and territory governments and federal governments all potentially asking the same questions, not to mention all of the departments and agencies within those governments also asking the same questions, seeking to verify the same thing, and generally making your life very difficult because there isn't good tell us once arrangements. So into this problem stepped the federal government with the concept for a federal image verification system. And that image verification system went by the fancy name of the, let me just find a name because I can never get it right, amongst other things, the National Facial Biometric Matching Capability, or shortened to the capability, and that was to be facilitated through an interoperability hub. Now, I now need to get this image up because it's an image of what the hub looks like. So let me just see if I can get you the image of the hub. Now, what was interesting about the hub, and I'm going to talk as I get this sorted out, is that it was, in fact, the subject of a detailed privacy impact assessment, and that privacy impact assessment was by no lesser an authority than Malcolm Crompton, the presenter in the first of these sessions. So it's clearly done by a very competent and experienced assessor. And the issue really was, as Malcolm identified it, that the capability was, he was asked to assess the capability in essence for its functionality as an central interoperability hub that enabled various state agencies to share information with each other. So the diagram he drew, which showed the focus of the privacy impact assessment, correctly described and is that image now showing, or have I messed it up yet again?
No, we're looking at the National Facial Biometric Matching Capability slide.
Oh, hallelujah. Okay, thank you. So this is actually figure 1 from Malcolm's impact assessment as done in 2015. And what it really identifies is that Malcolm was asked to look at the privacy impact assessment of how the central hub was operating, when in fact the hub was not a significant repository of the relevant information itself. It was a mechanism for exchange of data between a requesting agency and a source agency. So it had an important role in facilitating the secure and verified transmission, verified as in that the requesting authority had the requisite authorities to request that information, but it didn't in any way look at the issue of whether, for example, in the diagram, agency A and agency D had an agreement with each other as to how and where that information might be used. So an agency was, in essence, accredited into the use of the interoperability hub, but the arrangements between the individual agencies at the spoke of the hubs were not the subject of a privacy impact assessment. Now, that the assessment rightly said that before this capability is developed and put into place, there needs to be a much broader assessment of the relationship between the various agencies and the limits put around how this information may be used. Because, for example, if you think about an agency that might, for example, have CCTV cameras all over, say, the city of Sydney, and has found people of interest for whatever reason. They might have been, I don't know, not cleaning up after their dogs in the park, and the camera in the park showed the person who'd not picked up the doggy doos. They might be looking for whether the image of an individual captured from that CCTV was an individual known to, for example, the Victorian driver's licence database. So the issue then becomes, firstly, is it the responsibility of the federal agency that provides a capability, and this capability of interoperability of all of these agencies, many of whom are state and territory, to sort out some baseline rules around how information is to be used and when it might be permitted to pass through the hub? Or is it just its responsibility as the provider of the hub to make it safe for information to pass, for example, in encrypted form, reasonably safe from the risk that it goes to the wrong destination or that it is intercepted and viewed in the course of transmission? So that's what the prelim privacy impact assessment concentrated on and what it had to say about what needed to be done. And of course, what happened subsequently is that the Federal Department of Home Affairs really kind of zeroed down on the safe conduct, the safe management of the hub, and said, well, no, it's the responsibility of the agencies themselves to determine the rules as to how and when information is shared between them and for what purposes. So that in turn raises the question of what is the scope of organisational accountability that should be expected of organisations that elect to provide a hub or a capability that is then used by other agencies. The second question then becomes, well, if you're going to set some baseline rules in the centre, how detailed do those rules need to be? And do they just look at the issue of privacy impact? Or should they look at the broader question of, given the potential for a capability like this to be used to unduly surveil individuals and identify individuals through facial recognition, do we need a baseline set of constraints in the centre about the purposes for which, the circumstances in which this exchange might be permitted? And for example, when the intergovernment discussions took place around establishing the interoperability hub, there was a decision made and recorded in the minutes of those discussions that where the information was being exchanged for the purpose of investigation of an allegedly criminal offence, that it should be a criminal offence which carried a penalty not less than imprisonment for a period of 3 years. So to go back to my doggy-do example, the doggy-do miscreant could not be investigated if that rule had been applied, because I'm assuming now that in every state and territory in Australia, not picking up your doggy-doos doesn't potentially expose you to 3 years or more in jail. So when you look at the capabilities that are enabled through, sorry, I forgot to mention the last bit. When the legislation to give effect to the hub was introduced into the federal parliament, it didn't include the requirement that if used to investigate a criminal offence, it be an offence that carried imprisonment for 3 years or more as a condition. And when questioned as to why that had not been included in the implementation, the Department of Home Affairs said, well, that's a matter that can be dealt with by intergovernment agreement and doesn't really need to be part of the legislation for the hub, because the hub is just that. It is a mechanism for exchange of information. It is not the appropriate place to set the rules for what information is exchanged, for what purpose, how and when. So I think it's an interesting example because it has some of the issues of the COVID safe debate around access to information and the circumstances in which governments might have access, mandated access to information, and when that is reasonable and when it isn't. And it also involves similar issues to COVID safe as to the responsibility of the federal government to manage the proper management of information enabled through an app that the Commonwealth makes available by contact tracing agencies in the relevant states and territories. So it is an example of where, were it not for the provision of this capability, it would not be possible for Agency A and Agency E to connect other than on a direct basis. And given the range of agencies in Australia, the number of agencies, it would be impractical for many agencies to establish direct connections with the full range of other agencies. So the establishment of this interoperability hub does fundamentally change the extent of potential uses of facial biometric matching and image matching across the country. And if it is treated as merely a hub that is not treated as an issue of managing biometric information end to end, you end up with a real question as to, well, who should be managing it? If it isn't the hub that manages the spokes, how can we be sure that the spokes will manage the entirety of the wheel, the hub and the spokes, adequately? It also raises the question of the role of interagency agreements and the extent to which, when you get into more fundamental issues such as what degree and extent of surveillance do we as Australian citizens regard as reasonable in order to get single point of entry of data and more convenient ways of exchanging information between agencies? To what extent do we want the sharing of this information to enable law enforcement activities or potential detection of terrorist-related activities? And what kinds of conditions that might we then want around the type of information that is shared and the circumstances in which it is shared? What may we want around transparency requirements or oversight requirements? Should there be any reporting provided out of the central hub as to the circumstances in which it is being used, the number of times in which it is being used, the number of times in which requests have actually led to successful enforcement action, or some other metric that gives us a sense of whether it is only being used as is reasonable, necessary and proportionate given its potential impact on citizens and so on. So I think both the COVID safe application and the National Facial Biometric Matching Capability Interoperability Hub, to give it its official title, are good examples of how it is important when thinking about privacy impact assessment to make sure that you properly scope out what you're thinking about, to not be too narrow in defining what a privacy impact is, and ensuring that you look more broadly at impact on rights, and that you, when you look to build such powerful capabilities, you build in the necessary and appropriate controls and safeguards and requirements for separations and training of relevant staff within relevant agencies to ensure that the use of information that may significantly affect human rights, including a right not to be unduly surveilled, have been appropriately managed and can't be inadvertently or accidentally overridden by statutory powers of particular agencies to seek access to this information outside of the controls and safeguards that you've established. So what I'd suggest we do now is open up the mic to any discussion that individuals might have of those two examples, and invite people to participate in the chat. And I'll just hand it back perhaps first to Kimberly for her reaction to the two examples and how, whether we are learning things through this process. And because it's interesting, in point of time, the interoperability hub privacy impact assessment and the scoping of what Malcolm was asked to review in that assessment was in 2015. Subsequent to that, we had the issues around My Health Record and the audit conducted by the National Audit Office, which recommended improvements in the controls and safeguards around access to My Health data records. And now we have the COVID Safe app. And each time, I think the standard has actually lifted and addressed some of the criticisms that I and many others have made of each of those processes. So I'm this week feeling optimistic that we're on the right trajectory, but we've still got a way to go. Kim, what's your view? Are we improving, or is COVID Safe just different because the government was so keen to sell it?
Well, I mean, I think there's a big difference between a situation where the government is saying, this is the law we're going to enact, and this is the thing we have to convince you to download because we're not actually going to enact a law making you do this. So they were undoubtedly much more conscious of the need to sell the COVID Safe app. But look, we're almost right on 6, so I do want to see if there's anyone who wants to raise any hands, make any comments, tell me whether my pyramid and, you know, thinking about things in terms of the pyramid just can't ever make sense. Tell me we can't draw red lines. There's been a very fierce discussion in the chat about some of the red lines that we might draw, which I'm going to enjoy reading over later. But, you know, as I say...
Hello, it's Teresa here.
Hi.
Hi. I was staying quiet in case someone else wanted to jump in, but I thought I'll pick up on your invitation about drawing those red lines and flag that I think the vigorous conversation within the chat, and in fact the examples that you're raising, flag the need for ongoing conversation about who's drawing the red line, in what context, for what benefit, and then enabling, again, you know, and obviously, you know, I would say this, allowing that two-way conversation so that you have the opportunity to identify someone or some group that is detrimentally impacted by the drawing of that red line that you may not have known about because they haven't surfaced or they haven't been able to be surfaced. The challenge is, and to me, this is then connected to the trust issue once again, because am I going to feel comfortable coming forward to let you know that I exist? If, as difficult as my position might be, being invisible, at least by being invisible, I'm not on your radar. So, you know, I'll close on that, not because it's an answer, but to say I think the fact that we're having these conversations as an informed audience flags that there's a need to have much bigger ongoing platforms for these kinds of discussions so that we can then come up with both those individual and collective rules. And I'll close there, but thank you very much, both of you.
Yeah, look, I think one thing I'd say on that is that civil society organisations play an important role in this as translators in the debate and ensuring that the voices of the vulnerable and less voiced are heard. And I'd particularly like to call out some of the work that Lauren Solomon and the Consumer Policy Research Centre in Victoria have been doing around the uses of data affecting citizens. I'd also like to just call out that the Office of the Privacy Commissioner in Canada has just closed a consultation period around AI and no-go zones and appropriate rules to constrain ways in which AI might be used. And the OPC, the Office of the Federal Privacy Commissioner in Canada, applies very similar legislation to our own. And as we know, Canadians are just like Australians in fur coats. So it's always worth watching what the Canadian Commissioner has to say, because they tend to apply very similar reasoning around the balancing of individual rights and organisational responsibilities to those that we hear from the Australian privacy commissioners. So that consultation and the paper that started that consultation is, I think, an excellent discussion of no-go zones and appropriate principles for deciding when individuals' reasonable expectations of privacy or human dignity are being contravened.
Peter, if I could just point out just a small administrative issue. Folks, we are right on 6 o'clock, and I hope you enjoyed this conversation as much as I did. I was expecting a lot. I got slightly more than I expected, so thank you very much, Kim and Peter, for that. We now, if we're in the physical world, this would be the part where we break for drinks and cheese and you come and talk to the speakers in a casual environment. I need to break and go to my next meeting, but I'd encourage you to stick around and ask those slightly less in-camera questions of Peter and Kim. And if you have been clever enough to prepare cheese and wine at your own home before coming to this session, I invite you to encourage you to have that. Thank you very much for coming to this masterclass session. These masterclasses are about surfacing issues and to ensure that we are talking about the right sorts of things, and will be a wonderful feed-in to the Privacy Summit on Friday as part of Privacy Awareness Week. Thank you all very much for joining.
Thanks, Ian.
Thank you everyone for attending, and just a reminder that there is a link to all the materials for this session in the chat. You're welcome to explore that.
And we've still got an open mic for those who are able and willing and interested in chatting. So